Quasi-criminal offenses. Technically, laws passed by the provinces, territories, or municipalities are not considered part of criminal law. They are referred to as quasi-criminal law because they resemble criminal law but do not deal with actual crimes. Examples of quasi-criminal offenses are traffic offenses that fall under the Highway Traffic Act of each province and bylaws passed by municipalities. Breaking these laws usually results in a fine. For some quasi-criminal offenses under provincial jurisdiction, a court appearance is not usually necessary unless you enter a plea of not guilty. Indictable offenses. These offenses are more serious and are prosecuted in more detail. There are no limits imposed on how much time can elapse between the alleged act and the arrest, which means that such an offense may be prosecuted years after it actually happened. However, once the accused is charged, the trial must occur within a reasonable amount of time, usually less than 6 months. Minor indictable offenses are treated similarly to summary offenses. The accused is permitted to choose the trial procedure for some types of indictable offenses, although for some indictable offenses, the criminal code states that require trial procedure, but usually the choice is up to the accused. There are 3 types of trial procedures. 1, trial by a provincial court judge. 2, trial by a superior court judge without a jury. And 3, trial by superior court judge with a jury. The most serious of indictable offenses, such as murder or treason, are tried before a judge and jury. The maximum penalty for such offenses is life imprisonment. Examples of indictable offenses are assault, murder, robbery, and kidnapping. When you go into a courthouse, you will notice the docket, or list of cases for the day. A criminal case will show up differently than any other type of case on the docket, as it will look like this: R versus person. The R stands for Regina, the federal government, and V stands for versus, or against. Therefore, R versus person would be the federal government against person. Hybrid offenses. Known also as dual procedure offenses, these may be tried as either summary or indictable offenses. They are typically viewed as serious in some situations and less serious in others, depending on the circumstances surrounding the criminal activity. For example, if an accused has no criminal record, the Crown may decide to proceed with the charge as a summary conviction offense. If the crime involved the use of weapons, it may be considered an indictable offense. In these situations, the decision on whether or not to prosecute the offense as summary or indictable is up to the Crown. If the Crown cannot decide, the judge will decide for them and usually proceed summary offense. The methods that police may use when arresting individuals for summary conviction offenses are substantially different from those used when arresting a suspect for an indictable offense. Both the arrest procedures and trial procedures of the different criminal offenses will be looked at in a future lesson.